Beginning of personality. Every human being possesses a personality. According to the Turkish Civil Code, personality begins at birth and lasts until death. Therefore, birth is the beginning of personality. For a child to be recognized as a person, two conditions must be fulfilled: complete birth and birth alive. Requirements for the beginning of personality. According to the Turkish Civil Code, for the beginning of personality, two conditions must be fulfilled: complete birth and birth alive. Complete birth. Complete birth means that the child must be fully separated from the womb of the mother. There is no clear provision in the Turkish Civil Code, which defines the moment of full completion of birth. However, generally, the moment the child is separated from the mother's womb, with all the organs, is considered as the moment of full birth. For a birth to be regarded as fully completed, it is unnecessary that the umbilical cord is severed. However, some authors maintain complete separation of the child from his mother's womb and cutting the umbilical cord. Birth alive. It means that the child must be alive after separation from the mother's body, and it must live independently even if for a short period after completion of birth. For a child to have a separate personality, it is adequate being born alive. That the child shows any signs of life, such as breathing, heart beating, crying, or similar reflex of life, is the proof of being born alive. A child gains personality within the meaning of the law when it shows any sign of life after birth. Legal status of unborn person. Personality begins with the birth of the child. Before birth, the fetus has no personality or legal capacity. However, under certain circumstances, an unborn child may have personality. A child in the mother's womb, though not yet born, will have a legal capacity from the moment of conception, provided that it is born alive. Article 28, Para. 2 of Turkish Civil Code provides that the unborn child possesses the capacity for rights from the moment of its conception, provided that it is born alive. Under this situation, the child in the mother's womb is considered as already born if he is born alive. End of personality. Personality ends with death. Besides this, the presumption of death and absence produce the same results as death. Article 28, Para. 2 of the Turkish Civil Code considers death as the end of the personality. Anyone who dies cannot be entitled to any right or debt after death. In the same way, when a person dies, his or her personality rights cease to exist. Since personality rights are absolute personal rights, they are not transferable or inheritable. Death. Death is the end of life, and personality ends upon death. Because death is a gradual process, and it occurs in stages, therefore, it is vital to determine the exact moment of death in medical and legal practice. Biological death. Biological death is the traditionally accepted criterion of death. According to this criterion, permanent cessation of respiration, circulation, and heartbeat are regarded as the moment of death. This criterion of death is no longer adequate in determining the moment of death because of the significant advance in medical science and life-saving technology. Brain death. Today in Turkey, brain death is accepted as the moment of death. However, the law on transplantation of organ and tissue contains no terms about brain death. The Article 11 of the law on transplantation of organ and tissue states that for the purpose of this law, the medical death is established unanimously by a committee of 4 physicians composed of a cardiologist, a neurologist, a neurosurgeon, and an anesthesiologist via applying the rules and methods at the level of science in the country. As seen from this provision, the law uses the term medical death. Legal consequences of death. Personality ends upon death. Anyone who dies cannot be entitled to any right or debt after this. When personality ends, personal rights also end up with death. The patrimonial rights of a deceased person pass to the heirs. However, the rights strictly bound to the person, name, marriage, guardianship, etc., extinguish. Definition: presumption of death. Under normal condition, when a person dies, his or her body is identified, and after a determination that the body belongs to that person, his or her death is proved. However, under some situation, a person is disappeared in such circumstances that although his or her death is certain, his or her corpse cannot be found. A person may disappear in an airplane crash, a shipwreck, fire, flood, earthquake, or similar fatal danger. For example, if an aircraft, on which the person boarded explode in the air and the person disappears, the person may be presumed to be dead. Legal consequences of the presumption of death. When a person has been registered dead because of the presumption of death, he or she is presumed to have died. The registration of death gives rise to the same consequences as a natural death. Presumption of simultaneous death. Article 29, Part 2 of Turkish Civil Code provides that if more than one person dies in any circumstance and not possible to determine which of them died first, all of them are presumed to have died at the same time. Under some events, several persons from the same family may perish because of disasters such as an earthquake, flood, landslide, or other type of accident. Absence. Article 32 of Turkish Civil Code provides that where it is highly probable that a person is dead because he disappeared in danger of death or is missing for a long time, the court may declare this person absent upon application of persons who have rights in such death. The difference between the presumption of death and absence is that in the first case the death of a person is certain, but in the second one, the death of a person is uncertain but probable. Requirements for claiming declaration of absence. Disappearance of a person. Disappearance means it cannot be precisely determined whether the person is alive or dead. According to TCC, there are two situations to claim a declaration of absence: the disappearance in the danger of death and the inability to hear from him or her for a long time. The disappearance in danger of death does not mean that a person is definitely dead. If the death certain, then the presumption of death comes into question, not the absence. A specified period must have passed. In case of disappearance in danger of death, 1 year must have passed from the moment of danger. In case of failure to receive news for a long time, 5 years must have passed from the moment of receiving the last news. Consequences of the declaration of absence. General consequences of the declaration of absence. When the court declares a person absent, the right derived from the death of that person may be enforced as if the death has been proven. The consequences of declaration of absence in terms of family law. Under Turkish law, a declaration of absence does not dissolve a marriage. However, the spouse left behind may claim its dissolution. According to Article 131 of Turkish Civil Code, the spouse of the person declared absent cannot remarry unless the former marriage has been dissolved by a court.